like in this case, then the court must immediately refer the file to the High Court. She then again turned around. Instead of following the regulations she had followed earlier, she turned around and said she is unable to tell whether they have finished 180 days, therefore she cannot refer the file to the High Court. Then we adjourned again. We were objecting to the amendment of the charges, and we are telling her we came to court as ordered by the court, and we made an application to release our clients on bail, because the Constitution says if an accused person has been in custody for more than 6 months, 180 days, they must be released on bail. That's what we call mandatory bail, and no other proceedings can go on before the consideration of bail. So the court agreed to hear our bail application, and at the end of it, the court did not grant bail, saying that it has no jurisdiction, it should be the High Court. Although the law is very clear that the subordinate court, that is a magistrate's court, can grant bail. The magistrate cited practice directions, practice rules. In law, the supreme law is the Constitution, followed by statute law. Regulations come a distant third. So we did not understand how the magistrate preferred regulations to written law and to the Constitution. Thereafter, we asked on behalf of our clients to have the case referred to the High Court for bail, because that's the order of things. And we pointed out to her the practice rules, regulations she was showing us. Practice regulation number 10 says if 180 days have passed and the magistrate feels she cannot grant bail because the case is triable by the High Court, like in this case, then the court must immediately refer the file to the High Court. She then again turned around. Instead of following the regulations she had followed earlier, she turned around and said she is unable to tell whether they have finished 180 days, therefore she cannot refer the file to the High Court. Then we adjourned again. We were objecting to the amendment of the charges, and we are telling her stay the proceedings, we go for revision in the High Court. She asked for an adjournment, and we went and saw our clients. Our clients' instructions were, since the court is challenging us to go and file revision, our clients want us to prioritize their freedom and revision. So we have withdrawn to obey our clients' instructions to go and file revision proceedings. In the meantime, we have left court. We do not know what is going on. But our clients' instructions are clear. We cannot proceed against their instructions.
What if I proceed without you now?
Our clients are there. They have given us the instructions. We are in court because of our clients, not because of the court. So our first duty is to do our client's duty, and we told the court as much, and we did. Anybody who wants to